Maurice Thompson, 1851 Center for Constitutional Law, to provide interested party testimony. Welcome.
Thank you. Thank you for having me, members of the committee. I'll attempt to be no longer than the last speaker, hopefully a bit more brief, but I'll also be happy to answer whatever questions you have. I founded the 1851 Center in 2008. We're a nonprofit constitutional rights firm. We litigate matters of government overreach, so as you can imagine, it's been a busy year for us. I believe it was the last speaker, may have been a couple ago, mentioned that most folks have been unsuccessful in their litigation against state government. That is true. Our litigation has been almost exclusively successful, and a lot of the points where it hasn't has been due to mootness, where these orders come and go very quickly, which is an important consideration for you folks. When you're talking about the balance of the powers and the notion of the judiciary checking the executive branch, you have to understand these ephemeral orders are hard to check when they come and go so quickly and without notice. And courts aren't always quick enough to act, as some of you know through your experience. That said, we did win the Rock House Fitness case, opening gyms, declaring the early stay-at-home orders unlawful. We did win the Kalahari case, opening amusement and water parks, declaring the stay-at-home and business closure orders unlawful. And we did win the Community Montessori case, opening daycares, declaring these same types of orders unlawful, particularly in that instance where the legislature's ratios and daycare limits were overruled by the administrative state. So we've been down this road many times. We know the constitutional limits on these orders pretty well at this point. And I suppose what I'm here to say today is that HB 90 is very meaningful reform that will make my life a lot easier than it has been over the past year. It'll keep me out of the courts, and, well, it won't keep me out of the courts. It'll allow me to move on to other issues. And it will stop bogging down the courts with all of these kinds of cases, which is beneficial to everybody, and allow for more responsible and accountable decision-making regarding pandemics by the administrative branch. Briefly, I would like to address the following topics. 1, why this reform is important. 2, why the recent amendments to the bill are important. 3, why recent amendments render the bill far more meaningful reform than the alternative, which is Senate Bill 22, which is largely symbolic in my view. And 4, why the objections to this bill that I've heard so far all necessarily fail. So, first and foremost, why this reform is important and really long overdue. And this is a matter of standards. The General Assembly has delegated, as you all know all too well, ultimate authority to the Department of Health with no standards whatsoever. And the law on this is longstanding, it's clear. I believe it's best summarized in the Michigan Supreme Court's decision checking the authority of Governor Whitmer in October of this past fall. Not necessarily because that decision stands on its own, but because it summarizes 2 centuries of American law, both at the federal level and among state constitutions. And the rule is pretty clear. The scope of the authority and the timing of the authority and the details all work together. These are all factors you have to consider. If you're going to delegate authority of a great scope or that's very broad, then you have to be very specific in that delegation so that the administrative state can't run the economy however they like, essentially plan the economy without the legislature at the table. And you also have to have very narrow time limits. The problem with Revised Code 3701.13, 3701.14, many parts of 3707 are they contain none of these limits. These are very broad delegations of authority that have been taken and run with by the administrative state for the past year, and they contain no durational limits whatsoever. The orders are not required to take place in a state of emergency, and they're limited only by their own text, so they can last for a year, 2 years, 5 years, 10 years. And emergency rulemaking under 11903G is limited, depending on how you read the rule, to either 120 days or 180 days, and at that point, there's nothing prohibiting an agency or the governor from passing on the next day the exact same rule for another 120 days or 180 days. Through these provisions, the legislature has given away its authority and allowed the administrative state to run the entire legislative power of the state over the past year, more or less. And this is a real problem. This turns the Ohio Constitution's intent and meaning on its head. If you look at some of the framers of the 1851 Constitution, and what some of the scholars who were also framers said after that constitutional convention, and you have to remember, I think this was totally lost on our last speaker, our state constitution was voted for by the people. It was enacted by the people, and in Article 2, Section 1, what we have is we have the people giving away some of their policymaking power to the General Assembly and retaining the rest for themselves. And you all know it well. It's Article 2, Section 1. The policymaking power for the General Assembly is there, and then, of course, initiative and referendum is retained by the people, and that's the words used in the Ohio Constitution. None of their lawmaking power is delegated to the administrative state. The only source of the administrative state's authority is you folks and what you give to it, and you could expel it entirely. You could pass a bill rescinding all of Revised Code 119 tomorrow, all of Revised Code 3701 tomorrow, and that would be entirely constitutionally permissible. In fact, it would probably be more consistent with the intent of framers of the Ohio Constitution. As one scholar said, the purpose of the state constitution was to put the authority of lawmaking in the hands of the legislature and then take reasonable steps to tie the legislature's hands. So the administrative state was not really envisioned. So the time for this reform is really quite long overdue, particularly when the administrative state has been so brazen in avowing that it's basically doing the legislator's job. And let me give you a few examples. And one of the things that come up that you folks don't see is when we litigate these cases and we do discovery and we force the state to have to answer some questions about the evidence and why they're entitled to do this. The presumptive Senate candidate who was running the Department of Health at the time, in response to one of our interrogatories, said this: the director's generally applicable orders are legislative acts and general policy decisions, and this was to justify why no procedural due process was required. If you go back to the initial days in March, April, and May, businesses were presumptively closed with no procedural due process, no opportunity for a hearing for a business to show up and say, hey, we can operate this thing safely, or hey, why are we closed, why a similarly situated business is open? No opportunity for hearings. So we challenged that under procedural due process, and the defense of the Department of Health is we are basically the legislature exercising legislative authority, and when legislative authority is exercised, no procedural due process is owed, which is a true axiom in and of itself. Continuing in that discovery, the statement was the amended order is a legislative act of general application, and a state can make general policy decisions, as the director did here. The point was to frame the Department of Health and the director as a policymaker, explaining, quote, Dr. Acton weighed the danger from the spread of COVID-19 with the needs of Ohioans to obtain necessary goods and services. Well, this weighing process, this balancing process, is a process for the General Assembly. It's not a process for the administrative state in a vacuum with no oversight whatsoever, with no check whatsoever, with no opportunity to bring them in and for you to question them, or no time limit whatsoever. And the Ohio Supreme Court has even said so, which is another reason it's time to do this. The Ohio Supreme Court has said in the past about 370921, another health department source of authority, and these things are everywhere like landmines, that there's no unfettered policymaking authority in any of these statutes for the General Assembly. Policymaking, quote, from the Ohio Supreme Court in 2002, policymaking requires a balancing of social, political, economic, and privacy concerns. Such concerns are legislative in nature, and by engaging in such actions, the petitioners, in that case the Lucas County Department of Health, have gone beyond administrative rulemaking and usurped power delegated to the General Assembly. And the whole point of these cases is that, for better or worse, you folks have to talk to your constituents, you have to face your constituents, you know what they want done, and you have to face re-election. You're accountable directly to the public. So even if you wanted to, the purpose isn't to protect you, it's to protect the people so that you can't give away your lawmaking power, so that you can't not be held accountable on an election day. Our framers didn't want a situation where you folks went back and said, I can't do anything about what the Department of Health is doing, so don't base your vote on the Department of Health's policies. It's supposed to be your policies, so you can stand for re-election based upon the situation on the ground in the state. So, secondly, why these recent amendments to HB 90 are important. I've had discussion and asked for several amendments based upon our litigation experience and how the state is defending these laws. And I've asked for a generalization of the limits, and you've wrote strong language and inserted it in HB 90, generalizing the limits. Originally, HB 90 referred almost exclusively to the powers in 3701.13. Well, after we won a number of cases, the governor hired his own private attorneys, paid for at taxpayer expense, and they began arguing that the source of their authority was not 3701.13, but actually 3701.14. So it's important to also pay attention to that statute. And of course, we've got other instances like 3707.26, which gives local health departments the power to prohibit all public assemblies and to close any school, public or private, for any reason. Again, no time limits, no scope limits. None of these statutes have any limits on the types of authority, on the criteria that has to be satisfied in order to take these acts. So these little landmines are everywhere throughout Title 37 and even sometimes beyond. So what you've done is you've generalized the limitations through the text of HB 90, which is very, very important in actually creating meaningful reform. And I thank you for that. Two, you have inserted language that requires automatic expiration of any rule or order after 30 days, rather than relying solely on the power of rescission. I think that's very important because, if nothing else, it negates any of these concerns about the power to rescind through resolution. I think that this power of automatic expiration for 30 days, with your authority to re-up the regulation, if you agree with it, if these folks come in and give you testimony and you agree that this is an effective policy that's making a difference and should last for another 30 days, you still have that authority. But otherwise, the power to let the order or rule expire after 30 days is probably going to be used far more often than the rescission by resolution power as a matter of practical reality. And it's really an effective check, and also a reason for the administrative state to come to you and prove their case as to why the order or rule should last longer. And if they don't make their case, which they've never had to make once over the last year, because courts don't even open the book to whether the policy is effective or not. They just presume effectiveness, and then we'll litigate the case from that standpoint. This would be the first time they've actually had to make their case on why their policies are effective. And they should have to do that if they're going to maintain these policies that affect private rights to the point where imprisonment is the penalty for noncompliance with any order under 3701.352. So they should absolutely have to do that if we're going to put people in prison or fine them. Third, I've recommended, and you've added, and I appreciate you adding, a textual change that prohibits any restriction from continuing beyond the 30-day mark, instead of just any substantially similar order. This is a divergence from SB 22 that I think is very wise. And the reason I think it's wise is we've litigated issues such as Ohio's one-subject rule that you all know about in Section 15 of Article 2, and maybe some of you have seen sort of the quagmire that takes place when even the Ohio Supreme Court attempts to decide whether a particular piece of legislation contains one subject or not. And what you get is this bending over backwards and straining to find in favor of the legislature, to find one subject, even when there could be disunity. And the Supreme Court says, we're going to defer at all costs. and it has to be blatant disunity. So most of these things get upheld, which probably makes you folks happy. But it's an example of the fact that that one subject rule, as many of you will quietly concede, hey, we violate all the time around here, if we're being honest. And the reason you violate it all the time is because it's very hard for courts to enforce based upon its language. I think the same problem is true of substantially similar. You can easily imagine an Ohio Department of Health regulation that forcibly closes, say, bars and restaurants, and after 31 days, they amend the order to make sure that it closes bars, restaurants, gyms, and daycares. Well, at that point, it's no longer a substantially similar rule in the eyes of the government. It's a totally different rule because it's far more broad and draconian, and a court may find that those limits endure. So adding a limit of 30 days on any restriction in any of these orders or rules, I think is incredibly important and absolutely the right move as a policy matter to ensure that there's actually teeth in what you're attempting to do here. 4, also very important, venue for plaintiffs in their home counties. As many of you may know, there was a flurry of litigation. A lot of it was by unqualified attorneys who were simply copying and pasting our pleadings and motions, unfortunately. And all too often they would sue the state in their home county, Erie County, Carroll County, all over the place. If we won a case somewhere, that court would experience a flurry of filings, the next week or month. And almost all those cases got removed here to Franklin County under some arcane forum rules, whereby if you're suing the state, you can only sue the state in Franklin County. This is a terrible policy and something that may be worth you folks addressing long term. But what that does is it emasculates Franklin County voters and basically says, look, all important constitutional questions are going to be made by Franklin County courts in the Franklin County Court of Common Pleas, who are only elected by Franklin County voters and therefore don't represent 95% of the Ohio public and the Ohio General Assembly, obviously. So that's a very important change. It's also convenient to allow business owners and homeowners to challenge these regulations in their home counties. That's a very wise change. Thank you for making it, and I think it's very important. And then the 5th important change is attorney's fees for prevailing parties. And my experience with the General Assembly is that you folks can be very gun-shy about this issue because, well, each side has reason to be gun-shy for different reasons. But what I do want to say is that this just fills a hole. There is tremendous precedent for attorney's fees for prevailing parties in constitutional rights litigation. 733-61 allows for recovery when cities act unconstitutionally. There's a similar provision in Title III for counties and in Title V for townships, in Section 1983 and 1988 at the federal level for federal violation of constitutional rights. So this is nothing new under the sun, and I do think that it can help turn some ambulance chasers into bureaucrat chasers in an important and productive way that will maintain Ohio's constitutional balance of powers. Let me move to the next subject very briefly, which is that HB 90 is serious reform, while SB 22 is nothing more, in my view, than political theater. SB 22 contains none of the serious limits that I've just described. It basically rests almost entirely on the power of rescission by resolution. And as you heard, there are folks that want to challenge that on day one. And we can get into whether that works or not, but to hang your hat on just that one issue, rather than also the automatic expiration that you folks have featured in HB 90 is quite a difference, just a massive difference in my view. And let me close by dealing with some of the objections that I've heard sitting through today and also hearing a few from some of the prior committee meetings. And more or less the big 5. But first, I can't help but note all of the objections are coming from governmental actors instead of from your constituents, from citizens in the private sector. I've heard only objections from people whose sustenance comes from taking our tax dollars and allocating it to themselves or to their public budgets. And you ought to query why that is, that nobody from the private sector is storming in here to complain about this bill, and all of those whose power may be diminished are complaining, and that might lead you in the right direction alone. And I do also wonder about the politicization of the Department of Health and also the local departments of health, who have an association, as you know, who showed up here to oppose the bill, engaging in, they could have testified as interested parties, as I'm doing today, as a person who runs a charity and must remain neutral. But by expressly opposing the bill, there is an element of politicization there that makes you wonder what level of politicization is also taking place in their policy making that they shouldn't be doing in the first place. First of all, you've heard that the effectiveness of the administrative regulations will be hurt by this bill, but you haven't been, nobody has explained why in any of the testimony that I've heard. I read some, I listened to some others today, and I haven't heard a single example, not one example of one policy that one, worked to limit the harm caused by the pandemic, and two, would be prohibited by HB 90. Not one. And I don't think you folks have either. Not one policy that was effective, that has been proven effective, that will be prohibited by HB 90. And they haven't given you an example because they cannot. There's no such policy that's been both proven effective or would be outright prohibited by HB 90, because this is a process bill. This is a good government bill. You're not prohibiting any substantive policy here. What you're doing is providing checks and balances. And these folks seem to be political actors who want no oversight and no checks or balances or accountability. But of course, the policymaking function is yours. The next objection that I've heard is this: you can't possibly respond effectively during an emergency if this bill is passed. Another quote I wrote down was, future efforts to contain emerging epidemics in Ohio would be doomed to failure by design. Again, they would have 30 days to enact their policies and prove that they work to you. And this idea that now is not the time and you can't do this while the house is on fire. Fires don't last for 11 months, folks. Emergency powers and rules were made for tornadoes and hurricanes and earthquakes and terrorist attacks and all kinds of, there are some other examples in the revised code about products that are dangerous getting into the supply chains. Emergencies weren't meant to last 11 months, and if they were, why not 22 months? Why not 33 months? What is the cutoff date at which it is the time to act, and we stop deferring on the basis of an emergency? This emergency power can go on forever if they want it to, if you don't rein it in through this bill. And again, the statute 3701.13.14, some of these never should have been enacted in the first place. That's not your folks' fault. We all know how this works. A lot of them would have been snuck in to a budget bill or something at the last minute that you didn't have time to read. And it wasn't even you. It was, a decade ago, sometimes a century ago in some cases. And these powers in a century have never been used for this purpose. So you didn't know they were here. But now that we all know they were here, and now they're all being used in this way for the first time ever, it's precisely the time to rein them in. The time was 100 years ago on some of these statutes. Finally, rescission by resolution. This is perplexing to me. Through the muffled testimony of the prior speaker, I heard an assertion of unconstitutionality. This power is obviously not unconstitutional, and the argument turns the entire Constitution on its head. The notion that the legislature can't overrule the administrative state when the administrative state's powers flow solely from the legislature, which the legislature could entirely take away, well, that's an absurdity on its face. It's an absurdity if you read Article 2, Section 1, and look at how the powers are delegated. And then if you take a magnifying glass and read the other 80 pages of the Ohio Constitution and look for any delegation, any constitutionalized delegation of power to the administrative state, you'll find none. The term Ohio Department of Health appears nowhere in the Ohio Constitution, and it need not even exist in the first place. And of course you have the power, and sometimes I'm disappointed that you have the power even by committee to do this. After Governor Kasich almost unilaterally rammed through Medicaid expansion of the Affordable Care Act back in 2013, with the help of the controlling board, again, a committee or board of the General Assembly. I challenged that in the Ohio Supreme Court, and the Ohio Supreme Court very coarsely said, no, Thompson, in fact, they do have this power, whether you like it or not. So whether it's the controlling board or JCAR or any of these other boards and commissions and committees, a lot of policymaking has been taking place by delegation for a long time. So this is something that you can do. And in fact, what you're doing is remedying an unconstitutionality in the first place. So remember, what we have currently, the current status quo, is a number of statutes with no standards, no fixed standards for how they are to be applied through the intent of the General Assembly. So what you're doing is you're adding some fixed standards and some accountability, some durational limits, which are critically important, and some scope and substance limits, but mostly the durational limits. So what you're doing is curing a constitutional problem, if anything. And you know, this notion that you can't do rescission through resolution because it's not a law. First of all, the rules and orders are not laws, okay? You know, they're subservient to statutes. We all know that. But you folks especially know that because within the past year, you passed HB 197. And what does 197 do? Well, it contains a ton of uncodified law, what the Ohio Supreme Court calls uncodified law, which is exactly what a resolution is, exactly what resolution, rescission by resolution would be. And I'll quote this to you. And you'll remember this because, as you know, you made amendments to the public meetings rules, for example, the Public Records Act. These are statutes, 147, 149, Revised Code 122. You all know this. And you made changes about the enforcement of these revised code sections, and you did it through uncodified law, just like a resolution is, which means it doesn't go in the revised code, but it is part of the state law. Here's what the Ohio Supreme Court says about uncodified law. Uncodified law is law of a special nature that has a limited duration or operation, just like a resolution rescinding an administrative order, and is not assigned a permanent Ohio Revised Code number. Because uncodified law is not a law of a general and permanent nature, it does not appear in the statutes in codified form. And while uncodified law is part of the law of Ohio, it cannot be used to displace statutory language where the meaning of a statute is clear. So you can't displace a clear statute with uncodified law, but you can certainly displace an administrative rule or regulation with uncodified law, just as you displace an administrative rule through not enacting it through JCAR now. So I don't have any doubt that you folks can do this, but I think that the belt and suspenders approach that HB 90 takes by requiring automatic rescission in the event somehow that you couldn't, solves the problem anyway. And it especially solves it if you think about it pragmatically. If we run the numbers here, you're 10 days into a rule or regulation that's going to expire in 20 days. You folks pass a resolution rescinding the administrative rule. Well, at that point, the state's on the clock. They have 20 days to sue you. We have a problem about who the Ohio Attorney General is representing in that litigation. And who gets appointed, you know, whose contributor gets appointed special counsel to sue the General Assembly, with the Ohio Attorney General appointing that person and then defending the General Assembly. And of course, after all of that smoke clears, it only makes a difference if somehow they get an injunction against you within that 20-day remaining window in which your action actually matters, because the rule is going to expire in 30 days anyway. So, you know, if I'm you and I'm implementing a number of differing reforms here, and I'm just looking at the law on uncodified law and the entire structure of the Ohio Constitution, and looking at, you know, the pragmatics of how litigation works out, I'm not worried at all about this rescission by resolution issue. And even if there is a little bit of ambiguity there, there's no harm in trying it, because what you're trying to do is interject standards into a standardless regime that has allowed one or two agencies to centrally plan our entire economy for the past year and put people in jail if they don't comply with that central planning. So unlike SB 22, HB 90 here is a number of good reforms that I think would make a significant difference and significantly improve the balance of power in Ohio. Appreciate your time. I'll take questions if you want to.
Thank you for your testimony. We do have some questions. Representative Ginther.
Thank you again for your testimony. We appreciate the explanation and your views in this regard. I do have a couple of questions. First of all, has there been in your opinion, has there been a violation of the parameters or the limitations of 3701.13, or does the language 3701.13, the Department of Health shall have ultimate authority in matters of quarantine and isolation, which it may declare and enforce, or you alluded to the fact that there has been a shift to 3701.14. Does the language in 3701.14 grant the breadth of orders that we have seen without a violation of the Constitution?
It's a wonderful question, Chairman Wiggum, Representative Ginter. It's a wonderful question, and the way that we have framed our litigation since the outset is to say that the Department of Health exceeded the authority given to it in 3701.13 as well as 14 in enacting these sweeping industry-wide shutdowns at the risk of criminal penalties. And if it did not exceed its authority, then it certainly, then the statute itself exceeds the outer boundaries of the Ohio Constitution separation of powers. That is to say, if they do have that authority is flagrantly unconstitutional. And courts have gone different ways on that issue. So in our initial victory on this matter in Rockhouse Fitness, the court ruled that actually what happened was that the director exceeded the authority of 3701.13. And that's why these stay-at-home orders failed constitutional scrutiny, because of course you can't exceed the authority given to you by the General Assembly, where that violates the separation of powers as well. The Ohio Supreme Court said in the 1940s that there's no power to shut down a business otherwise lawful, and that the legislature could not give away that power. That's a case called Weber v. Butler County Department of Health. And so we quoted that case extensively for the notion that this power never existed in the Department of Health in the first place, as interpreted by the Ohio Supreme Court. I have to tell you, conversely, however, the language is exceptionally broad, and it runs the risk of emboldening those who want to seize power and run with it to do just that. And by the time we're able to litigate these matters and the smoke clears, it will have been months. The Rockhouse Fitness ruling in our favor was in, I want to say, May 22nd. All of this stuff started in mid to late March. So we're talking about 60 days of problems before we could get a court order somewhere that in fact would affirm these principles. And so that's another problem, another reason to narrow the statute, the scope of the statute, the standards surrounding the statute, is because in this instance, people were scared. That included judges who are, after all, people, and it took 60 days to get any resolution for Ohioans.
Mm-hmm. Follow-up? Thank you. Thank you, Chair. So I guess we've heard, and I'm just drilling down on these to re-emphasize for myself and for those who may be listening in. So we have heard over and over again, and you've already touched upon this, so I almost drew a line through my question, but I am going to ask it. Do you believe the language then in HB 90 would slow down the process and the response and endanger the lives of Ohioans in any future such emergencies as we've experienced?
Well, I think first and foremost, the burden is on these folks who oppose this bill, the Department of Health and these other governmental actors appearing in a political capacity here, to give you at least one example of one policy that would have been slowed down or made less effective, saved one less life than if this regime existed a year ago today. I haven't heard one example. I could tell you that we dig into discovery in these cases and we start asking hard questions about to the Department of Health, requiring that they prove the efficacy of their policies. Give us all the evidence that your policy has made a difference. The only thing they can ever provide that I've ever seen from them over the past year is correlation. Well, we passed this policy and cases went down a little while afterwards. But what they don't tell you is all the examples of where they passed a policy and cases skyrocketed. It was after the mask mandate, for example, that cases skyrocketed in Ohio. And what happens when that's the case? Well, they say correlation is not causation, and the case number isn't our metric anymore anyway. Now we're going to look at hospitalizations. I say, okay, well, let's go ahead and test this hospitalization theory. And it turns out that there's no correlation between reduction in hospitalizations and some of the Department of Health's policies either. And then they say, okay, well, it's deaths now that we're going to look at. And the same thing turns out to be true. The Department of Health can't make a compelling evidentiary case to you that any one of their individual policies has actually saved some great number of lives or other kinds of damage, unfortunately. And so that's step one. And then step two is, would any of those policies even be outright prohibited? And again, the answer is no. The answer is those policies are going to have the light of day and the scrutiny that they deserve, and we're going to have this dispute about the evidentiary nature. We're going to be asking, well, why are things the same in Florida that doesn't have this policy as they are in Ohio if this policy is so great? Why have the numbers turned out the same in pretty much every state and every country, no matter what the policy is? And these are the hard questions that you'll be asking once these rules are implemented.
One more?
Follow up, please.
So we've heard a lot about the limitations and the role of emergency powers. Does the Constitution, does the Ohio Constitution grant emergency powers to the legislature?
Yes.
Okay. I like those straight answers.
Yeah, I mean, it's explicated in the Constitution, right in the front end of Article 2. In fact, it gives emergency powers only to the legislature, which creates a presumption that nobody else has them, unless perhaps you delegated them. You did delegate emergency rulemaking in 11903G, which has been a real problem. And let me just take the opportunity to tell you folks, one of the problems that we've had here through 11903G is that these are the rules that don't require JCAR approval because they're considered emergency rules. Well, here's what I can do under a normal circumstance. I can take a Department of Health order that's a generally applicable rule, and I could go to court and say, Your Honor, they're calling it an order, but it's really a rule by a law. Rule is defined in 11901C as basically some generally applicable rule of conduct that affects private rights. Almost all of these Department of Health orders are rules, so I could go to the court and say, they passed this rule without JCAR, therefore it's invalid. And that's what 119 says, is that if you do a rule without JCAR, it's invalid. But there's no reason for me to do that when they don't need to go ever to JCAR or anywhere else, because so what if the order was a rule? So what if it was rulemaking? It just ends up not mattering. So we've been, and this is, by the way, this is the Wisconsin Supreme Court's decision in Palm that was the first in the nation to overturn a regime like this, which is rulemaking without going through the rulemaking process in Wisconsin. And there again, basically the only state to open through constitutional decision instead of through some other sort of action. And again, the same results that we do in Wisconsin since that court case was, since that decision was issued in early May.
Okay. Representative Fowler, author.
Thank you, Mr. Chairman. Thank you, Mr. Thompson. You packed a lot into your testimony, so I'm still digesting it all. But you said a couple things that I wanted to kind of clarify. One, it sounded like maybe there are a lot of other areas that you're bringing to our attention that have impacted people throughout the state. Are there areas outside of House Bill 90 that we will continue to need to look at for reform specific to health rules or orders, or will House Bill 90 enable the legislature to address those should they ever come up in the future?
Representative Wiggum, Representative Fowler, I would keep you here all night in answering that question truthfully and thoroughly, so I won't do that.
Before another committee.
Yeah, I could go on this topic, and maybe we will some other time. I can tell you that, generally speaking, it would be a good idea for a more holistic review of the balance of powers between administrative and legislative at some point. And let me just give you maybe just one or two examples. Take the example that we talked about, where everything runs through Franklin County Court of Common Pleas. When an agency enforces its order or rule against a citizen, it doesn't matter if it's in Ashtabula or if it's down in Hamilton County, or if it's in another far-flung county, if it's in Mahoning, somewhere 3 hours away, that person gets an administrative hearing, if they're lucky, and then they have to appeal it to the Franklin County Court of Common Pleas, elected by the voters of Franklin County and Franklin County alone, giving the Franklin County voting bloc this extreme authority over what's constitutional and what's not, and what agencies can do to Ohioans and what they can't. And this is a real problem, and it intertwines with the issues we're seeing here, where everything's funneled through Franklin County. And so giving venue in home counties, as this bill does, at least on these kinds of issues, is a good start. And I think a reform there is a process reform, but ultimately it may be a substantive reform because you have more neutral judges elected by a multiplicity and diversity of voting blocs actually weighing in on the constitutionality of agency actions over the long run. And I think that there are far too many sleepy hamlets in Ohio that have the resources in the judiciary to handle these issues. And the other thing that HB 90 does not do, but ideally would do, is, it does leave Ohioans twisting in the wind for those first 30 days. If you look at, as just one example, Revised Code 3717, and that's the restaurateurs licensing rules. It requires an immediate hearing. If your food license is suspended by the local Department of Health, you get an immediate hearing within 5 calendar days. If they do it without a hearing first. But it requires a hearing first. And you get an immediate post-deprivation hearing if they do it beyond 5 days. And in fact, the Sixth Circuit Court of Appeals said within the last year that it would violate procedural due process to not provide either a pre-deprivation hearing before you close a business or an immediate hearing within 3 to 5 days. And they use that number of days. Some courts even say 2 days, some circuit courts. Okay, that's federal constitutional law. So we still are in a position here where these folks are going to get no due process, no procedural due process for the first 30 days after agency action, and they're going to basically cross their fingers, hope that you folks rescind by resolution right away. But if you don't, they don't get a hearing, and this is one of the things we argued for early on, and the state said it's not going to give you hearings. As I say, they made a number of elaborate arguments over why they don't believe that people are entitled to procedural due process, entitled to hearings to prove that they're safe when safety is the whole goal all along. So I think the procedural due process angle and an opportunity to create the evidence that proves people shouldn't be summarily shut down, for example, should be part of this equation. We have nuisance lawsuits. We have all kinds of ways for local health departments to shut down individual businesses if they're bad actors who are jeopardizing the public health in one way or another, including through pandemics. That has been around for hundreds of years as part of the English common law, and it can withstand at any time. And that individualized approach to dealing with harmful behavior is really far preferable in every way to this sweeping industry-wide prophylactic approach that you're all shut down, and if you violate one of these orders, you're going to jail.
Follow up.
Thank you, Mr. Chairman. Thank you for that. And then I wanted to ask regarding your comments about having some suits that went through the judicial process. We've had some witnesses that suggested it would be more appropriate for those who've had contentions with the health orders to go through the judicial process. And my observation has been that in many counties, our governments and courts have not been open to the public. They've not been as available. Can you speak to, if this bill doesn't pass, what people's right for redress of grievances would be through the legislature or other processes?
It's a great point that you make, is that a number of common pleas courts shut down to the point where, look, when we were litigating, we went to the courts that were open. And if we went to the website of a county where we had a client and the website said, close until further notice, not doing hearings, we didn't file in that county. And that client may have been out of luck in some cases. Now, it happened to work okay for us because it turns out the courts that weren't so afraid to open their doors also were maybe inclined in our favor in some of this litigation. So that worked out okay in some cases, but it took a very long, again, it took 60 days. You know, it took 30 days to even find any client, and it took another 30 days to establish a record where the state said it's making policy in order to escape the procedural due process issue before we could go to state court with the separation of powers issue. And then, you know, courts are slow to act. So whatever you can do to stop this freight train on the front end prevents us from having to stop it after it's picked up some steam, which is much harder to do. So look, the judiciary is a very important branch of government, and I think the judicial checks, particularly as guardians of our Constitution, are the highest duty of any branch at any time. And those have worked out in some instances, but there are all kinds of procedural pitfalls, particularly when you have inexperienced and unqualified attorneys with businesses that are panicking as clients, as was the case here, just, you know, rushing to file a copy and pasted complaint and hoping it all works out. Turns out the court's closed, you know, they can't get a preliminary injunction hearing. So this is actually worse during a pandemic to get judicial review than it even is under normal circumstances, which can be sometimes too slow. So it's all the more reason to do everything you can to get out on the front end.
Thank you. Representative Kelly.
Thanks, Mr. Chairman. Thank you for coming in. I'm looking forward to seeing your written testimony because, like my colleague said, there was a lot to unpack there, and so I just wanted to make sure that I was following all of it. I was trying to take copious notes. So I wanted to make sure that I was understanding correctly that you are testifying as an interested party for
Correct.
this legislation?
Thank you. Yes.
Okay, yeah, I appreciate that. I just wasn't sure, because you certainly have a lot of knowledge on this subject, and it sounded like you were very involved in, you know, a lot of conversation around it, so just wanted to make sure that I was clear on that. And then I also thought that you said, as part of this, you know, that this type of law change is important for purposes of litigation. But in another part of your testimony, you were talking about some of the cases that you'd brought against the state. And so, did you say that you won all of those cases?
No.
And is it just like a handful? And I guess that's sort of also to my colleague's question, just about the availability of courts and, you know, if you had people who are interested in having, you know, legal redress for their issues, you know, how many people were prevented from doing so?
Well, we lost our first case, which was a challenge to the non-essential business ban as not providing any procedural due process, any opportunity for hearings for those whose businesses were prohibited. You know, in our practice, sometimes you've got to lose the first one to win the next 5 or 6, which is what happened here, because government lawyers lie, and the way they lie in the first case prevents them from taking the opposite position in the second case. So when they said the director was exercising legislative powers, we said, well, good, now we've got them on record saying that they're the legislature, so we can go make a separation of powers argument in state court. So that's another reason these things sometimes take a while, is sometimes the government lawyers will say anything that they can to win, which is a real problem of ethics at the Ohio Attorney General's office that's persisted during my entire career.
Follow up, Mr. Chairman? Thank you, Mr. Chairman. So I will also say to that, as I've said to several other witnesses, you know, that if there are issues like that or conduct that is not consistent with what it should be, that hopefully you will report that or lodge a formal complaint or something like that, because I think that all of us want to make sure that our government works in an ethical and transparent way. So whenever you win those lawsuits, then who pays who pays for the award to your client?
Representative Wiggum, Representative Kelly, nobody. So here's I'm not sure if you're asking about the attorney's fees or the potential damages to the client, but I can tell you the answer to both. We're a nonprofit constitutional rights firm. We take no money from our clients. They don't pay us a fee. We have small donors who are nice enough to send in $50 or $100 here and there. And that somehow manages to work out, because after all, if the cost of hiring us was $10,000 or $20,000, they would never challenge these regulations, and these things would go unchallenged. So we have to do it that way for them. We cannot recover our attorney's fees in these kinds of cases against the state. So it is the black hole. If they were against the city, we could, there's something called a 733-56 action. If it was against a state, if it's against a local government in federal court, we could as well. We can't sue a state in federal government in federal court under the 11th Amendment immunity. So we've got a problem there. So we've got to sue a state for constitutional violations of the state in state court. And if we do that, we've got to go to the Court of Claims if these folks want to be made whole in any way for any damage done to them by the state. And that's the exclusive jurisdiction. So if we have a money damages claim, we get bumped from any county in Ohio to the Court of Claims, even if our primary issue is a constitutional concern, and that's what we're seeking to litigate. So it's a real line-walking experiment where, frankly, these businesses never get made whole. You also have your 2744 sovereign immunity rules in Ohio, which prohibit any sort of, it's kind of like qualified immunity at the federal level. So any of these businesses that were just frivolously closed, and we had a restaurant in Ashland that was just absolutely frivolously closed, we won that case. But that person will never see a dime for all of the food that it spoiled when they were immediately closed without notice, for example. So the state never pays damages in these cases is the sad reality. The best we can do is black out the rule or regulation that's causing all the harm and stop the bleeding.
Follow up.
Thank you, Mr. Chairman. So would anything in this bill change that ability then to recover? Because I know one of the things in the sub-bill would be that it requires the state to pay attorney fees and court costs. So would that be then presumably different than it is now?
I think that's a big help. And the reason I think that's a big help is because it gets a lot of attorneys off the sidelines sooner to say, hey, I can represent a client who cannot afford to pay me anymore because I can now represent them for free and hope to recover my costs because I believe in this case. You know, the one area I didn't mention, we've won multiple eminent domain cases where localities have frivolously sought to steal people's land through eminent domain. And wisely, under the Batchelder years, the General Assembly put a provision in Revised Code 163 that says if it's proven that the attempted taking of the land was not for a public use or necessary, then the locality seeking to take that land has to pay the attorney's fees once that's proven in court. And what that does is it gets good attorneys off the sidelines to represent people for free. They look at the taking and say, this is for a mall, it's not for a public use, so I'm going to represent these folks, charge them nothing, and then recover on the back end. So that it does make a tremendous difference to authorize attorney's fees. And I would say that the reason that constitutional limits on the state are under-enforced as compared to in other areas, you know, First Amendment litigation is proliferate, ubiquitous. Every day a new First Amendment case is filed in the Midwest, maybe even in Ohio. And that's because there are economic incentives as well, so that you don't have to break the bank as a private law firm. So I think you inducing that may make it easier to enjoin improper administrative conduct sooner. So I think it's critically important. If you were to attach a damages claim to it, I think that you'd end up in the Court of Claims even if you didn't write the bill that way, and it would create all kinds of messes.
Yes, one follow-up.
Thank you, Mr. Chairman. Thank you for that. And then just my last question, I know sort of interspersed throughout your testimony, you had talked about folks potentially being imprisoned for violating health orders, and I just wasn't sure if you were aware of anyone who actually was imprisoned because of violating health orders.
Representative Wiggum, Representative Kelly. So I have a client who was tasered for attending her son's football game outdoors without a mask, without being within 50 yards of anybody else. I have a client in Cambridge, Ohio, who charges were brought against her for operating her restaurant. This is, you know, a grandmother with no criminal history. Charges were brought against her in the municipal court by the municipal prosecutor for running her restaurant without a license. The charge brought was a second-degree misdemeanor. We were able to get that charge dismissed, so she was not imprisoned, fortunately, in my opinion. I have a case that was not, well, I don't have a case. There is a case that, because we were so busy, we were not able to take, where a grandmother in Kenton, Ohio, permitted her granddaughter to play on the playground during the time when the state criminalized playing on the playground back in April and May. And she was, because this is not our case, she received poor legal representation that she paid $10,000 for. She lost, she was convicted, and she awaits her sentencing, and she may go to jail for that. And again, this is somebody's grandmother with no criminal history.
Thank you. I have a couple of last questions here also regarding this. In prior testimony, we talked a little bit about the fact that what this bill does actually is places in law. Okay, so what we're doing is placing something in law that gives us the ability to go through the to rescind and or extend, these health orders. And so the statement before, and I want a little clarification from you, is that it was unconstitutional to do such a thing if we place it in law. Even if we place this law into place, we still can't do a rescission, even though we put it in law that we can. Can you tell me where in the Constitution this testimony may be coming out of, or why that would be the case?
Well, from what I heard, which was limited, this individual's claim is that Article 2, Section 15 indicates something along the lines of that a resolution is not a law and cannot rise to the law. There's certain ways that a law becomes a law, and it's the Schoolhouse Rock process of passage by both houses and, of course, signature by the governor, which we all know, we all wish was true, and we all know not to be true for multiplicity of reasons. But that was the claim. The problem with that claim is that you're not creating a law. And when you rescind an administrative rule or regulation, you are creating a condition and a standard upon which administrative decision-making is to be exercised, which is precisely the job of the General Assembly when it does delegate the authority to fill in the gaps. The purpose of administrative decision-making, Mr. Chairman, is to fill in the gaps when the General Assembly leaves things a little bit too broad. Make the air clean, make the water clean is probably too broad, so you narrow it a little bit when you delegate authority to the EPA, and they say, okay, clean air means particulate matter of X amount percentage per volume of air or whatever. So that's their job, is to fill in the gaps, and that power comes solely from you, and you can condition the exercise of that power however you want. You can require it to go through JCAR, and in fact, the Ohio Supreme Court, Nally v. Fairfield County, a decade ago, over and over again says when these agencies make rules without going through JCAR, the rules are invalid and they're immediately invalidated because that's a condition that you placed on the making of administrative rules or orders, which you have total and complete authority to do. Again, you could eliminate administrative rulemaking altogether. You could eliminate an administrative agency altogether if you so chose. And because you can do that, you can also obviously condition the exercise of the powers that you give them. They come from you.
Right. Okay. And I was wondering if he was looking at something, if we were looking at something just in Ohio's Constitution. I just thought this was interesting because we just got this from the Senate today, and I'll pass this out to the whole entire body here. But I mean, Alabama, Alaska, Arizona all do joint resolutions. Arkansas, California, Colorado do joint resolutions. I mean, I've just started going through this and looking at this. It's a comparative analysis of what other states are doing and have done. So, obviously, if our Constitution doesn't say that we can't place in law the ability to put conditions, which would allow us to do a resolution, then I could understand. But if the Constitution doesn't say that, then I'm not sure where that's coming from.
Well, Mr. Chairman, if you can create one of the biggest line items in the state budget, the expanded Medicaid provisions through the controlling board, then we know that boards and commissions and committees can do a lot in Ohio, maybe more than some of us would even prefer. This we know to be true, and as the questioning indicated, JCAR can be involved in all these processes, and that's always been upheld. And so I don't really have any concerns. If a committee, JCAR, can put a stop to an administrative rule, then certainly the entire General Assembly, a more democratic forum, could put a stop to an administrative rule or order.
Okay. Thank you. Representative Grindell.
One quick question through the chair. Thank you so much for all this testimony. It'll take me a while to reread some of your testimony and to understand some of it. But do we have the power in our oversight committee that we're creating or the General Assembly to modify one of the orders?
Does
If
the
you
text
can
of
answer
HB 90 give you that authority, Representative Grindell? Is that what you're asking me?
It doesn't, but yet, I don't know. Could
Yeah.
we do that?
Okay. Good question, Mr. Chairman, Representative Grindell. So HB 90 does not grant the authority to modify an administrative rule or order. I believe, okay, so it's a very good question. It's one I should have thought of previous to now. My initial reaction would be this, that you certainly would have the power to partially repeal an administrative rule or order. There's no doubt about that whatsoever. And if you look at that power, it would be equivalent to the power exercised by the governor, who of course has the line item veto power in the state of Ohio to simply cross a line through certain parts and not others. In fact, you may want to, we may all wish to reread HB 90 with an eye towards the issue you've raised, with the power to partially repeal lie. And I think the way you would handle it under HB 90 actually is that when the administrative rule or order is set to expire at the end of the 30 days, you would communicate to the agency, you know, we're not going to re-up this rule because half of it is exceptionally problematic, but the other half we don't have a problem with, so come back to us with the other half of the rule. And that's exactly the way that government oversight should work, you know, and that's the way that it could work under HB 90. So you could effectively ratify a portion of an administrative order or rule and rescind the other part through that deliberation process. And it does give you that tool. I hope that that helps answer your question. Thank you.
Thank you. Seeing no other questions from the committee, thank you again, Mr. Thomas.
Thank you for your efforts.
Yep. Okay, at this time, I'm going to hand the gavel over to the Vice Chairman, John.